Are live. All right. So, how's everybody doing today? I had to spend 20 fucking minutes out in the rain because my cat, Big Cat, decided that he wanted to be outside, which is fine. Not really, but it's fine. And he got into a fight, and this is a big 20-pound mother effer. And he is, I should make sure, I completely forgot. Excuse me. I need to grab a, delete that. I need to really quickly grab something. I forgot to open something, and oopsie, because I need it for this, uh, for the stream, and I'm just really, 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 really dumb. Oops. So it's not that. Is it this one? I think we got that meme ready for it, but that's neither here nor there. Not what I'm looking for though. I ended up having to do a clip yesterday concerning our girl Kay. I had to clip something she said in order to make sure is it this one? I think it might be
Okay,
this
can I?
one. Is it this? No, this is the recording I did. That's not so it comes from a couple of weeks ago when I was on her show, and I completely forgot to grab this, so that's on me. But it came from a couple of, let me find out where I fucking saved. I had to boot up the program. Hooray. It came from a couple weeks ago, and it's kind of important to give you an idea of exactly who she is, because I think it's important to know who she is. I guess I have to add something here. No, we're not going to go with that. We'll just go with something really short, so it'll. Okay, and then render as. Where does it go? Does it go to the finish? No, it goes to the desktop. Okay. I thought it went to the desktop. I was like, it goes to desktop, right? There it is. Okay. Maybe you specifically have. Okay. Important to kind of have it just to establish what kind of a piece of crap she is. And I've got that ready. It's not a long clip, but we will be going over it. So, anyways, my cat decided he wanted to get out, and I had to go out. And get him, and he got into a fight, which I'm very proud of him. He's a big pussy, but he's my kitty. Anyways, and whatever. So I spent 20 minutes trying to coax him out from under the patio, and I finally got him. But that also put off being able to cook my food, get my coffee ready. So I ate a very quick dinner and got my coffee ready. That's why I was a little late. So, Critical K, Karen Marie Yax. Let's give you a backstory on who she is. She is a YouTuber, holds herself up as a what's it called? A true crime YouTuber. And she is currently being sued for essentially accusing a woman of contributing to the death not only of her child, but also a patient of hers who was was a patient. She's a therapist, psychiatrist, something like that. And Kay is being sued for it because of statements she made on her stream, one of her streams, I should say, in which she basically accused the woman of contributing to the death of her child, which I don't know why you would fucking do that, especially after trying to tell me, oh, I would never say something like that, even though you're being sued exactly for that, you dumb twat. But, what are you going to do, right? What are you going to do? And I should have really taken care of all of this while I was preparing earlier today. I've been cleaning all day. So she's being sued filed an answer, filed a motion to dismiss specifically for lack of jurisdiction, personal jurisdiction. It was denied. She had a conference call. She had some kind of pretrial conference last year. She didn't attend it, and it was telephonic, so she could have appeared via telephone. She said she wouldn't, or she didn't. She was fined $100, a sanction $100, told don't do it again. And then she's told that this is happening. She files to appear telephonically, not in person. The court rightly rejects her request because, she was given a chance to appear telephonically previously, and she said no. She didn't even show up. And so that's kind of like the backstory on who this bitch be. Now, I know of her because of her presence in the Sophie Long drama, and she is absolutely fucking batshit insane. She specifically got into it to go after Mike Long, the father, on behalf of Kelly Long. Now, she did not read any documentation within the Sophie Long case, which, as a true crime channel, right? As a true crime channel, you would think she would have looked into that, right? Maybe you would look just a little bit into the case, read, do some research, but she didn't. She was specifically there to go after Michael Long. She didn't give a shit about Sophie, as evidenced by some comments she's made and people in her Patreon chat made, basically making fun of Sophie Long for being sexually assaulted. Yes, she fucking took part in that shit. So don't give me that shit, Karen. But she, she really tried to. Oh, it was bad. It was bad. But she admitted to me on the stream she read absolutely nothing about the Sophie Long case, and she didn't need to. All the while telling me, like the misanthropist she is, is it misanthropy? I can't remember. But she told me that men should not be talking about it. Only women can talk about it. Basically, the absolutely 49-year-old, God knows how many fucking cats. Her house reeks of cat piss, right? This kind of cat woman, a woman who's been divorced. Her kids hate her. Her new husband hates her. He settled because, he wasn't going anywhere. That's what kind of a piece of shit she is, right? She is a piece of fucking shit. And she's okay with it. This is a woman who attempted, actually, this is a great time to do it. So, let's bring this over. And I'm going to switch scenes now. And this is her own words, right? We're going to listen to this. And she's going to tell me she had nothing to do. I apologize for nothing. Almost fell on the cat, though, so I kind of feel bad. But you're going to hear her tell me, okay, that she had nothing to do with trying to get Ken Jennings, Kiwi Farms Ken Jennings, fired from his job. So I'd like to know how the sound is. This is, I think, the only sound clip I have. Let's listen to it. Maybe you specifically
right, when you say you guys, it's not, I don't have time for all that.
Encompassing phrase, because you guys, I watched you guys as you cheered, what was her name? The woman from New York who got Ken Jennings fired. I watched you and Squishy and all of them cheer him being fired simply for talking about the Sophie Long case.
Just to make very clear, I contacted Ken Jennings and asked him for clarification on whether he actually got fired or not. And he was never able to give me he was never able to communicate with me any specific cause of him being fired, reason he was fired, the day he was fired, who he worked for that he was fired. He was never able to articulate that to me. So when you say that Ken Jennings was fired, I mean, I don't know anything about that.
I personally, take it as you will. I have personally seen the email that was sent.
Wasn't sent from me.
No, it was not sent from you, but I saw you cheering it. That's what I said. Okay, so she says she didn't cheer it. That's a fucking lie. And I can actually bring up comments the Critical K was making. These are comments Critical K was making. Ken, tell your secretary to put me through to you. Tell Sarah to patch my call to you. Sarah being the alleged receptionist she thought was in charge of Ken, routing calls and everything at Ken's job. Tell Sarah to stop hanging up on me. Kenneth, the important thing is to discuss is the fact that she's been kidnapped. Tell Sarah to put me through to you. Now, these are all comments she was making. You know what the problem for her is, though? She was calling the wrong place because she couldn't dox worth of shit. And yes, she was cheering Lisa Sadowski, the woman who actually got him fired, who sent an email that I have seen, right? I've seen the email. Ken shared the email. I think he made it public. I think he put it out there. But Critical K was in his chat telling him to tell his receptionist to put her through to him. But she wasn't trying to fuck with his real life at all. Critical K wouldn't do that. Now, I should point out that about a month after this, the Critical K channel was deleted. It was terminated by YouTube for breaching their terms of service. Important to note, because when Nick Rekieta had his channel yeeted before he, Lazarus, he came back, she was actually saying Nick Rekieta violated the terms of service. It's not, he shouldn't have violated the terms of service. He just has to accept that he was banned. Ladies and gentlemen, did you know that, hey, has a new YouTube channel? Did you guys know that? Did you guys know that Critical K has a YouTube channel even though she was suspended? She had her previous channel terminated? That's right. She does. Just K is the name of the channel. But she wants to try to tell people if you're suspended for violating the terms of service, you just have to accept it. And by the way, notice the Just K mark there? Look at that. Do you notice the Critical K? Did you notice that? It's the exact same icon. So, but she was suspended or terminated August, I believe. So, maybe this hypocritical piece of shit should shut their fucking mouth. Just me. What else? Oh, and then just to give you an idea of how she tries to play to authority, during my conversation with her a few weeks ago, by the way, she's deleted this stream, by the way. Deleted the stream. I have an archive of it. 2 archives, actually. One on my end and one that is her stream itself. I have archives of it. And let's see. Yeah, there's some stuff she said, but one of the things that she said was that she tried to argue to me. She's like, I was a therapist for 25 years, and she wasn't, though. She tried to play to authority, except she isn't an authority. This is her licensing information. She was, obviously, it has been redacted just a little bit to protect her privacy, what exists out there. Occupational therapy assistant, which is a significantly different education set. I think you need essentially an associate's degree in occupational therapy to become an OTA. I could be wrong. To be a therapist is like, you actually have postgrad that you have to do. But the time frame doesn't matter. It was about 25 years. I'm not going to get into her for that. But she lied about what she was. She straight up told me I was a therapist. And in fact, I'm not going to go into it, but that's the kind of shit she did. All right. She tried to pull that a bullshit with me and hi, Feingold. Are you breaking out the fireball for the stream? I'm going to break out a kick to your nuts if you ever say that again, Roscoe. Anyways, so she tried that shit with me. Didn't work. Credit to Ken Jennings for having found this, by the way. He knew where to look. I don't. I wasn't even looking. I took her at her word. Okay, she was a therapist. I took her at her word. Didn't really matter one way or the other. Okay, so this is the kind of person she is. She is rules for thee, not for me. She doesn't do her research, which is part of why she's being sued for defamation. And then she pulls this kind of stuff. So she was sued last year, June of last year, I believe. She filed her answer to it, her motion to dismiss. The motion to dismiss was denied, lack of jurisdiction. There is a case from California. I can't remember. I should know it. I should fucking know it. It was against the National Enquirer. I can't remember what it was called. It wasn't Burnett. Was it the National Enquirer? I'm pretty sure it was. I can't remember what it was, but it basically says Calder v. Jones. That's it. Calder v. Jones. And it says that so long as you make phone calls into the forum state, you are subject to the long arm jurisdiction of that state as general rule. Now, obviously, full disclosure, not a lawyer, not pretending to be one. Not going to say this is good legal advice. You should not take anything I say as any type of legal advice. I'm reading over this stuff partially as a layman who wants to kind of dish on a bitch, but also as somebody who I fucking hate people like this. I fucking hate people who will go out of their way to get a man fired from his job and or cheer this because she's upset that his take on a situation doesn't conform to her take. And her take is, I just want to go after the man because I am a sad sack of shit. Okay, that's what critical K is. So do not construe anything I'm going to say as legal advice or anything other than a retard talking about legal issues. So after we get through that, she files all that. Then she had a pretrial conference that she could appear at telephonically, which means she could appear via Zoom. And she didn't. She didn't appear. And she was fined $100 by the court for not showing up as she was required to. And then this comes along, and the court is talking to her. You know, they're trying to set it up. She refuses basically to interact with the plaintiff's lawyer, and the lawyer says, "Hey, she's not talking to us." So the court is like, "Good, we'll have a telephonic conference, a pretrial settlement conference, I think it was called, October 30th or September 1st, something like that." It was August, end of August, beginning of September, and she 4 days before argues. 4 days before the conference, she knew about it for at least a month. She says, "Oh, I can't show up. It would be a financial burden and yada, yada, yada. And I just can't do it." And the plaintiff responds to it basically saying, "Bruh, she mailed a motion from fucking Hawaii on vacation. Bullshit, she can't afford this." I don't know what her financial situation is, but that's what that is what she argued, what they argued, and the judge agreed with the plaintiff and said, "No, Kay, you have to be here in person. Show up," right? And I showed up on her program like 2 or 3 weeks before it. I was like, no, it was the week before actually. And I said, "Hey, Kay, remember to make it to your, being helpful and also being kind of an asshole. Won't lie. Little column A, little column B." And I said, "Hey, don't forget to make it to your appointment." And she just, whatever. She didn't go. She didn't show up. She didn't go. And the court was like, "All right, you need to show us a very fucking good reason as to why you didn't show up." And she did. She gave a motion. She put a motion. We're going to read over 3 motions that were filed. One is the plaintiff, Ray Andriacchio, her motion for sanctions to include a default judgment against Kay. The second one is K's response to the motion for sanctions. And the third is the plaintiff's response to the response for the motion for sanctions. So let's get right into it, shall we? Now, I've tried to redact addresses. I know in one of them I was able to because she put it right front and center. I was like, hey, cool. So here we are. Let's. How do I zoom in? I can. Motion for default judgment. This is the Yak's response. We'll also. All right. Let's get going on this, shall we? Comes now the plaintiff, Ray Andriacchio, by and through undersigned counsel, yada, yada, yada. It moves for default judgment against defendant Karen Yaks. In support thereof, plaintiff states as follows to wit. And basically, they're just summing it up. Is broke as poor a good reason? It could be if she had attached any affidavits, if she had attached any bank statements, done anything to show evidence that she could not financially make it to this. She did not. And that was part of the reason that it was denied. She didn't attach anything. And oh, by the way, her motion to dismiss for lack of jurisdiction was left open by the judge. Later on, if you can show more evidence to support that this is the improper jurisdiction, you may file a further motion to dismiss for lack of jurisdiction. You may do so if you have new evidence. She's filed 2 further motions, neither of which has any evidence attached to support that this is appropriate, that the court lacks jurisdiction. Okay. Remember, she called people, interviewed people in Mississippi where this is taking place. Under Jones v. Calder, that's good enough. She actually had people on who talked about it, and I actually make a meme about it later. But let's go. On October 14th, this court entered the following order directing the defendant to appear in person for a scheduling conference on October 18th, 2022. That comma was not necessary. At 9:30 a.m., text-only order directing defendant Karen Yaks to attend in person the settlement conference set for October 18th, 2022. The court further notes the previous settlement conference was canceled and parties were directed to confer and select mutually agreeable dates for an in-person settlement conference via court order, docket item number 43. Defendant Yaks has failed to comply with court's order 43. This court notes that on 9/1/2022, a new notice of settlement conference was entered, setting settlement conference for 10/18/2022, and copies of the notice were sent to defendant Yaks via email and U.S. mail. Said notice advised that all persons are required to be present for settlement conference. This court has granted ample time for defendant Yaks to comply with its order and coordinate travel to attend the settlement conference. This court orders in-person attendance and notes that a failure to attend the settlement conference as directed will result in sanctions. No further written order shall issue. So, court said that she had to be there in person. She couldn't appear by Zoom or telephone. And again, she had a pretrial conference previously that was telephonic. She could have shown up, or she could have picked up the phone or started Zoom, gotten on there, had the conference. She didn't even do that. Notwithstanding this clear mandate from the court, the defendant did not appear in person for the scheduling conference. At 9:30 a.m., plaintiff and her attorney were present in court. Shortly after 10:30 a.m., the magistrate opened the proceeding in defendant's absence. So she wasn't there, and the bailiff or the magistrate was like, Bueller? She wasn't there. Defendant's failure to appear was deliberate. In a September 1st, 2022 email to the magistrate, of which the court should take judicial notice, and they will, defendant states, as a pro se litigant who is still objecting to Mississippi long-arm jurisdiction on the grounds outlined in my request for summary judgment, I am unprepared to validate long-arm jurisdiction by traveling to the state of Mississippi and subjecting myself to a process I am woefully ill-equipped to defend myself against this bogus suit designed to harass, intimidate, and terrify me. Because Karen is a perpetual victim. She could be a bully. She could be a bitch to people. But the minute her chickens come home to roost, the minute people fight back, she's being harassed. She's being intimidated. She's being victimized by the system or Ray Andriacchio or Ken Jennings or Spectre or whoever the monster of the day is for her. Moreover, in an internet chat, I believe this is her Telegram. I believe it's Telegram. I don't know. I don't use the social media. Which occurred on October 18, 2022 at 10:28 a.m. I think U.S. time zone map. I think. Okay, so yeah, okay, so Michigan is actually Eastern Standard and Mississippi is Central Standard. So this would have been slightly before. Okay, cool. I didn't know this. This is why I look things up before running my mouth most of the time. Even as the magistrate was about to address the plaintiff and her attorney in court, the defendant stated, and I know this is really hard to see. I'm going to read it for you. I can't make it bigger. I can't click on it to make it bigger. Critical K. The court threatened to sanction me again with a shrugging emoji. Last time they sanctioned me $100. Who knows what they will do this time? But I'm not going there ever. It's just not even possible. Basically, inviting the court to sanction you. Oh, they sanctioned me $100. They'll probably do the same thing again. No, they're not going to. Sanctions ramp up as you decide to flout the court's rulings and the court's decisions. See Exhibit A to plaintiff's motion for sanctions pursuant to Rule 16F, declaration of Renee Barfoot, incorporated herein by reference as if fully copied in words and figures. And I'm not going to pull that up. It just says, yeah, this is a true and correct copy. In view of the defendant's contumacious, and I had to look that word up, it's an archaic legal term meaning essentially willfully ignoring the court's direction. Refusal to comply with the court's order, plaintiff seeks entry of a default judgment, since no lesser sanction exists that would achieve the desired effect of making defendant comply with the court's orders. Plaintiff also requests that the court incorporate into the default judgment its findings from its order dated November 19, 2021, including the following statement about minimum contacts. Quote, a review of the available communication suggests that the defendant intentionally and purposely wished her words to impact the plaintiff in Mississippi. These are minimum contacts that the defendant herself creates with the forum state, Walden v. Fiore, quotation marks, and emphasis omitted. Plaintiff incorporates by reference her memorandum brief, wherefore premises considered the plaintiff, Ray Andriacchio, prays that this honorable court grant the default judgment. Furthermore, the plaintiff prays that the court incorporated into the default judgment's previous findings regarding defendant's minimum contacts with the state of Mississippi. The plaintiff prays for general relief, blah, blah, blah. So, she didn't show up. They are now moving for a default judgment. Will they get it? A default judgment so quickly? Probably not. And the reason for that is courts generally are not willing to go with the default or summary judgment so quickly without giving the, at least putting forward a little more effort. Alex Jones notwithstanding, that's just kind of how courts aren't. And so I don't think she will. It's a good argument to be made. I'll grant you that. She's constantly told the court to fuck off, essentially. So I can see the court doing it, but I don't know if they will. I am thirsty today. So, we got that. So, critical K response. And I had to delete her address because she put it there, which is fine, whatever. Don't know why, but here we are. Response to plaintiff's motions for sanctions and motion to show cause. Consistent with findings in Twombly, the Supreme Court made it clear that stricter pleading standards shall apply to all civil actions in federal court. Yes, they do. When a plaintiff gets close to stating a claim, but without some further factual enhancement, it stops short of the line between possibility and plausibility of entitlement to relief. In keeping with this, I don't know why she's fucking around. I think she just copy-pasted this, except she does the exact same thing down here. I don't know if it's some kind of an error. I don't know. Or she's just that stupid. And I believe she's that stupid. In keeping with this, the Supreme Court further expressed concern with the cost-expensive discovery on a baseless claim, saying that when allegations in a complaint, however true, could not raise a claim of entitlement to relief. This basic deficiency should be exposed at the point of minimum expenditure of time and money by the parties and the court. Twombly's standard was also involves the intangible value of ensuring that citizens, such as defendants who are unlucky enough to be named in meritless lawsuits, shall receive meaningful vindication. That plaintiff shall bear the cost of that vindication. So she is right now arguing what is called a 12b6 motion for failure to state a claim. It should be dismissed for failing to state a claim, except her motion to dismiss previously was only under 12b, I think it's 12b2, lack of personal jurisdiction. She did not state at the time in her motion to dismiss failure to state a claim. As a general rule, even as a pro se litigant, you only get one bite at the apple for pretrial motion to dismiss. So it prevents something like this from happening where the opposing party, the plaintiff in this case, has to spend more money to fight against multiple motions to dismiss. You can't do it as a general rule. Now, if something comes out later, that could change things, but that has not come out here. She's trying to argue improperly a motion to dismiss. It is with these sentiments that defendant, as an out-of-state resident living in Michigan, who has not waived her right in challenging the constitutionality of being subjected to litigation in an unfamiliar foreign jurisdiction to which defendant has never had even a passing familiarity with the form of Mississippi and the overall weakness of plaintiff's meritless claim of defamation, defendant respectfully argues that the court erred in their denial of defendant's motion to appear telephonically for the mediation conference on 10/18/2022. Really towing the line right there of sovereign citizen bullshittery. Just saying, hitting that line. Might want to watch it. Defendant raises two elements which serve as the basis of her defense in this responsive motion. She brings up three, but like Joe Biden. 2 words made in America. Defendant has been entirely self-represented as a reluctant pro se litigant. It doesn't matter if you're reluctant, but you're a pro se litigant while attempting to plead, respond, and navigate the confusing labyrinth of the federal judicial system and a foreign jurisdiction from out of state. This is fair. Pro se litigants have to navigate something incredibly labyrinthine. It is incredibly convoluted. And this is why you have an attorney. Okay? Just as an aside, DA Talks, I consider him an acquaintance. When he filed his motion to dismiss, unfortunately, he had filed his answer prior to it and argued a lack of subject matter jurisdiction and a 12b6, failure to state a claim. But then in his motion to dismiss, he argued lack of personal jurisdiction because he screwed up, or he didn't understand the difference between subject matter and personal jurisdiction. A lot of times a court will be forgiving to a pro se litigant, especially early on, not in something like that, unfortunately. Now, in his defense, Dean hasn't been told, yeah, this hasn't been dismissed, but it's probably going to be that way, unfortunately. So she makes a point. Look, I've attempted to plead and respond and navigate, and it's really difficult to, right? And it's from out of state. It's not like she can pull up, she can just drive down to the library or the local law school, check in the local law library and look at it. She has to go. It's Mississippi. She lives in Michigan. Bro, even Della Brooks had a more coherent argument. Let's not go that far. 2, plaintiff's repeated acts of hostility, physical threats to a person from her brother online. Her brother online doing something has no bearing on the plaintiff. She can't control him. Plaintiff's outrageous conduct and online harassment via proxies and leaking of these civil court proceedings. There's been no leak. All of this can be found literally on Pacer. Okay? We need to make that very clear. That's not what I wanted to pull up. I apologize. Okay? All of this can be found on Pacer. And I'll show you what I fucking mean. Okay? Uh, Andriacchio via yeah. So this is Pacer Monitor, which monitors Pacer, obviously based on the name. Here's Pacer Monitor. You can literally see it. You can sign up with an account, and you can download everything for 15 cents a page. Okay? She doesn't have to leak anything. It's all available to you, the layman. You know, this is, if you're not an attorney, you don't have a Pacer account, you can use Pacer Monitor and get everything for a monthly fee, essentially. You still have to pay for per page like you would with Pacer. So nobody's leaking, and I am certainly not a proxy of Ray Andriacchio. I've never talked to her. I don't know her. I am just talking about your stupidity, Kay. I literally, Twisted Puppet says I literally Googled it. It's not just on Pacer, it's on the court's website. Yeah, it's on the court's website too, but to get the documents, I believe you would have to have a Pacer account or use Pacer Monitor. Don't think you can download it from the court itself. I could be wrong. So, again, that doesn't hold water because I don't think it's happening. Again, she likes to act like a bully until people fight back, and then she's a victim. Stereotypical, Amber Heard, right? The narcissistic personality, which is exactly what she has. She is a narcissist. Her outright refusal to engage in private civil discourse. She cannot. If you're trying to contact Ray Andriacchio when she is represented, you are breaking the fucking law. I don't know about breaking the law. Maybe not breaking the law, but you are certainly doing something that the court can sanction you for. You do not talk to the opposing party. You talk to their counsel. More importantly, they have no reason to engage with you in private discourse. Everything can be done through the courts, essentially. The fact that they're returning your emails at all is a benefit for you. It's beneficial, but they have no need to do so. Has all but made it plain to the defendant that plaintiff is once again abusing the courts as a vexatious vehicle to economically harass and victimize the same ensemble of victims and to further raise the burden of litigation against defendants. No. She's doing what the court allows. Her attorneys are doing what the court allows. It's all within the scope. It's all within the it's all allowed. Okay? All of it's allowed. You're not being harassed. This is what is going on. Ray Andriacchio is not on social media talking shit about you, as far as I know. Her attorneys are not on social media talking shit about you, as far as I know. You've kind of been talking shit, but you've gone quiet all of a sudden because you know what just happened. I think. Again. Critical K. Twitter. She has like 500 fucking accounts on Twitter. I'm not even joking. Okay, one of them hasn't been used since 2020. I think that one ended up being she ended up stopped using it because it got hit by this is a malicious actor kind of thing. Also, blatant racism. She's racist. That's not even a joke. She's racist. And then her second account, she started retweet. She stopped tweeting retweeted something on the 25th, 16th. What's this about? Okay, so it's about Kylie. I don't know who that is. Anyways, she's no longer talking about Ray Andriacchio or the Andriacchio case. It's because she gets banned so much. Yeah, well, that the accounts aren't banned. I should say that the accounts are not banned right now. Although defendant does concede that by raising the issue regarding her lack of access to basic legal defense and counsel, that she is raising larger fundamental socioeconomics and constitutional rights issues which cannot be addressed or rectified by the civil court at this time. You don't have money. It sucks. Plenty of people get sued who can't afford it. It sucks, right? But you have to make do. You have to find a way to defend yourself or do something. And you were given an out with this fucking thing. You were given an out, and we're going to go into that when the plaintiff responds to this. If you'd shown up, you would have known this. Okay? It goes back to her and the other Karens don't know how courts work. Look, I don't know how courts work necessarily, but what are you going to do? However, defendant's sole purpose in raising the issue of a pro se status is to serve the court with contextual facts surrounding the timeline of events, both retrospectively and concurrently over the duration of plaintiff's suit. The court already knows you're pro se. Court has recognized multiple times you are pro se. You don't need to bring it up. It's another way to say I'm a victim here. That's all this is. It's her trying to play the victim. In similar light, defendant raises this issue in order to refute suggestions, English is really hard, which have been repeatedly made by plaintiff that defendant does not take this court or the petition filed against her seriously. It is no secret that defendant, acting on her own behalf, is a reluctant pro se litigant. It doesn't matter if you're reluctant, you're still pro se, and you're still subject right now, based on the court's ruling and case precedent law. You're not, reluctant. Has invariably resulted in poorly worded pleadings. Poorly worded would be generous. It would be generous to call these poorly worded. Improper filings. Okay, that's, you're pro se, that could be forgiven. Potentially waived rights and defenses among an entire litany of other detrimental preliminary rulings, including but not limited to defendant's ill-equipped attempt at filing her motion to dismiss. And other preliminary judgments that have adversely impacted defendant, not plaintiff. So basically she's going, I'm pro se, I'm also really, really fucking dumb, I can't use words properly, and because of that, I'm the victim. Forced pro se because she won't pay her legal fees. She claims, actually in this, we'll get to it, but she claims that she can't find a lawyer. Uncivil law literally told her how to fix her filings. Yeah, but that would require her to listen to a man in cold day in hell before that happens. I'm running low on coffee. I don't like this. As a result of defendants' innumerable failed attempts at retaining even the most basic legal counsel to impart on the multi-jurisdictional complexities of defending this case, leading up to the initial telephonic conference date of 12/15/2021, compounded by plaintiff, as a result, what's the result? What's the result? Compounded by plaintiff, brother Chris Thompson and counsel, and witnesses listed in initial disclosures, Renee Daughtry, Renee Barfoot, Misty Evans, Emily Harding, repeated malicious online posts and acts of online intimidation and manipulation prior to and leading up to both conferences. I have to say right now, and Twisted Puppet knows exactly what I'm going to say about this, and I know when Alyssa sees this, she's going to chuckle about this too. The fact this bitch is saying these people who are friendly with the plaintiff talking shit about me, this is inexcusable and unacceptable. It's detrimental to my fucking mental health. It's really fucking ironic when you consider that this bitch did the exact same thing during the Sophie Long case. She was one of the stupid twats who was going around attacking Alyssa, attacking Michael Long, attacking Nick Rekieta, attacking Ken Jennings, even attacking me to defend Kelly Long because they chose a side and they felt they were they were allowed to. So it's really fucking ironic that she turns around and then says, I'm getting the exact same treatment I gave to other people, and this is unacceptable. The court needs to step in and stop this. But previously, she said she has freedom of speech so she can talk shit about all of us. Go fuck yourself. Just saying. Go fuck yourself. Okay. Ooh. Ooh. I'm also going to put this out there. I just thought of that. Like, I read this and I was like, that's a little funny. The hypocrisy is fucking astounding. Defendant was fearful, whether real or imagined, that even appearing telephonically, she could be legally bullied or railroaded into conceding some sort of irreparable legal, financial, jurisdictional culpability by attending what she did not understand at the time was simply a case management conference. It was literally told to you, pretrial case management conference. Literally told to you. Want to make that very fucking clear. Sorry, I had to close that out. So, you knew exactly what was going on. You just didn't give a shit. You just didn't give a shit. You weren't going to show up. You admitted you weren't going to show up. You had no intention of showing up. And then to come back and go, I was going to show up. I would have shown up if I had known this is what it was. I think the court's going to see right through that, given that you were given previously a pretrial conference, case management conference, that you could appear at telephonically, and you didn't show up to it. I think the court's going to look at that and go, but we gave you a chance before, and you said, fuck you. Why would the court give you another chance even, you were given a chance, you said no, so now the court has to make sure that you show up, so they say you have to come in person. Understandable from the court's perspective. Further, defendants strongly contest the repeated assertions made by plaintiff that by failing to attend the telephonic conference that writing a check to satisfy court sanctions levied against her is of no significant consequence. I don't know that that's ever been said. Simultaneously denying herself key opportunities to participate in the process of advocating for her own interests is some sort of preemptive strategic means in achieving an advantageous or even desirable outcome for a defendant. Repeated assertion made by plaintiff that by failing to attend the conference that she's denying herself. Oh, yeah, okay. So she's denied herself by not attending. Okay. So poorly fucking worded. Basically, she didn't show up. So, yeah, she kind of shot herself in the proverbial dick. She did. You're going to be sanctioned. It's a question of what those sanctions will be. And the court is going to be really, 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 really tired of your shit. And that leash that the court gives pro se litigants will get shorter. To the point that you may actually have a default judgment against you if you continue this, because the court's not going to want to deal with a trial. It's going to be wasteful for the plaintiff. In the alternative, it is the defendant. That doesn't even fucking make sense grammatically. The 19th Amendment was a mistake. I'm just saying. Women get an education now, and then this happens. It is defendant, not plaintiff, who has been significantly impacted not only in the form of economic sanctions, which only further compounds her economic disadvantages in relation to plaintiff. Defendant has also forfeited her right to participate in the case management process by including but not limited to objecting to plaintiff's overly burdensome discovery requests. No, that doesn't forfeit your right to participate in the case management process. You objected to the discovery requests. Your objections were overruled. And you had to provide the discovery. You had to provide the discovery. That doesn't forfeit your right to participate in the case management process, because this came after the discovery, or at least that discovery request. Denying yourself opportunity to give equal input in case management deadlines regarding dispositive motions, you didn't lose out on that. You're being a fucking cunt and thinking you're above the law. Again, narcissistic personality disorder, not a diagnosis, by the way. It's a narcissistic personality. It's all about her. How is she the victim here? How is Karen Marie Yax the victim in all of this? And because her decisions are now having consequences, in reality, it's the plaintiff's fault for requesting the sanctions they are allowed to request. Shifting the blame. It's not my fault I didn't show up. It's actually the plaintiff's fault for requesting sanctions against poor little old me. That's not how that fucking works. This is happening because you didn't show up. Cause you didn't show up, effect. They ask for sanctions. Simple. So simple, I think a first grader would understand it. Cause and effect. You'll learn that very quickly. This is not quantum physics where sometimes an effect can precede a cause. When you get to, temporal physics and whatnot, it just doesn't work. This isn't sci-fi shit. God. I have no sympathy for her. Hope she gets wrecked. Yeah. The irony is since she and the other candidates kept calling Michael Long a narcissist. Yeah. I mean, I think there's a case to be made there, but the fact that this bitch is just sitting here acting like this, the court, I think, is going to see right through it and go, shut up. This is this. No, I've been accused of writing papers, like legal, like just straight up writing legal documents for people and submitting them on their behalf, right? Which would be illegal, and I didn't do it. I did format some stuff. Never disputed that. When I formatted it, it sure as shit looked a lot better than this. All right. And I barely know what I'm doing. Just saying. Where was I? Why does it look like she's trying to write a poem? Like these randomly. There's an enter press there. Like, did she have like a seizure? I don't know. Nevertheless, defendant does accept responsibility for her failure to attend telephonic phone conference last year. Cool, but are you taking responsibility for your decision not to attend this? Because it sure doesn't seem like it. You know enough to scare the fuck out of a lawyer from a PR firm. Yeah, good times. Good times. She was actually really pissed because I scared the shit out of a lawyer from a PR firm. I'm not sure if you saw that, Twisted, the stream, and if not, I can get it to you. We have an archive. Ken Jennings made the archive. Anyways, defendant did promptly pay the economic sanctions levied against her. It has nothing to do with this. Congratulations, you did what the court ordered you to. By your thinking, that actually puts you within the jurisdiction of the court now. Just saying. You're claiming that any action to appease the court would put you within the jurisdiction of the court, but you paid the sanctions. So wouldn't, by your logic, would you not now be under the jurisdiction of the court? I'm just saying. Get me the archive link. I don't give views to those. Yeah, that's fair. Well, she deleted it. She deleted the stream after, like an hour afterwards. That's why Ken made the archive, because he knew. She said some shit she shouldn't have. Defendant did immediately comply with all related discovery materials, except you didn't. And I'd have to go back and get it, but there appears to be stuff you say you have in your possession, specifically about proving some, I can't remember what it was, but you say you could prove something. She specifically asked for it, and apparently you didn't turn it over, and that's the subject of another dispositive motion. Just saying. So you didn't comply, unless you're saying that you actually don't have it, and you were making it all up, which would mean that, yes, you have defamed Ray Andriacchio, because you literally made it all up, which would meet the definition for defamation per se. That would be malice, actual malice. You don't care if it's true or not. You're just saying it to hurt somebody's, just saying. YouTube still has a copy, and ain't a lawyer worth of salt can actually feed the streams directly from YouTube. Yeah, they can. They can. I'm just saying. Defendant did immediately rectify her clerical mistakes, i.e. ensuring she submitted concise, properly headed, and legible materials and signed with certificate of service. Jesus Christ, you're a liar. This fucking document proves that you haven't rectified anything, because Jesus fucking Christ, if I was an English teacher, you would have a big old fat F with a "see me after class" in red pen all over this shit. And signed with certificate of service, which, by the way, I just want to show you what that means. I hereby certify that Karen Yaks relayed and furnished certified copies to plaintiff and counsel by way of U.S. postal mail. That's not how certificate of service works, but you can't just say, yeah, I'm putting this on the paper. Because what happens if it gets lost? Right? What happens if it gets lost in transit? I'm just saying, what happens? All right. As originally stated in the previously submitted confidential memorandum, defendant understands the benefits of attending in-person mediation. And yet, it is an important tool utilized by the court in order to conserve resources to find common ground between two parties and possibly come to a mutually agreed settlement in order to avoid costly, lengthy trial, in order to save everyone time, money, and unnecessary burden to the civil court system. This flies in the fucking face of what you said up here. You absolute fucking mongoloid. This flies in the fucking face of what you said up here. She can't even keep her story straight at this point. She's writing this down. She has the ability to go back and proofread before submitting it. And she doesn't. Ladies and gentlemen, pour one out for the fucking judge in this case. The magistrate and the judge. And you know what? Pour one out for Ray Andriacchio's fucking attorneys that have to deal with responding to this shit, reading over it and responding to it, because Kay is going to drive these people to drink themselves to death. I'm not even drinking and I can feel my liver rebelling. Regrettably, defendant maintains that it is precisely due to the detrimental, cost-prohibitive, lengthy, abusive process at the expense of the defendant in civil court, to which plaintiff seeks to harass and prolong this legal process, having no intentions of ever seeking a meaningful resolution in mediation. How do you know? You didn't even fucking appear! You don't even know what they were going to say to you during the mediation. You don't know what they were going to say to you. You are literally pulling this out of your fucking ass. Defendant does not have the disposable income to arrange for continual round-trip airfare, to travel to a foreign jurisdiction to engage in a 20-minute mediation conference with an undoubtedly hostile and vexatious litigant, which will inevitably result in a fruitless outcome. Plaintiff has repeatedly made it known to both the defendant and her affiliates that the suit is not for the purpose of seeking monetary relief premised on any sincere allegation of defamation or false light. Plaintiff has repeatedly relayed to defendant through several miscellaneous channels over the duration of her lawsuit that she has only filed this lawsuit against defendant to legally harass, punish, antagonize, intimidate defendant for entirely unrelated reasons having to do with her defamation suit. Really? Where's the statements? Where are the certified statements? Where's the affidavits from people saying this? You don't have them. You don't even have emails or text messages. You don't have anything showing that this is true. Nothing. You know what? Just to cover all the bases, just wanna make sure on that. She does have a bunch of. I want to see what these texts. Okay, so this is gonna be $3. Great. This is like $3.50. Fuck me. All right, I want to see what these are. All right, so Matthew Wilson posts on Facebook. God damn it. Okay, we're gonna look at this. I just spent $3.50, so fuck it, whatever. She did put something in here. God fucking damn it. I didn't even think that, whatever. But we'll look at these. So Matthew Wilson posted murder of Christian Andriacchio, Sleuth Syndicate. It looks like it's a Facebook group. Ray's attorney, Matt, and Karen were ordered to have a phone call by 8/6 yesterday. Karen says the court in Mississippi doesn't have jurisdiction over her. Pretty sure the courts make that decision, yet she still has not filed anything regarding jurisdiction. Actually, she has. It was denied. Karen is also claiming to be afraid of Matt, like physically afraid to speak with him over the phone as ordered by the judge. I think Matt, is that the, I think that's the attorney, right? Yeah, Matthew Wilson is the attorney. Wanted to make sure. YouTube still, bitch doesn't even know what vexatious litigant means. Yeah, I know. And then the correspondence, Miss Yaks, this correspondence is in response to your August 3rd, 2021 email. Federal Rules of Civil Procedure states as follows: conference of the parties planning for discovery, conference tuning, except in a proceeding exempted from initial disclosure under Rule 26A1B, or when the court orders otherwise, the parties must confer as soon as practicable. Pursuant to court's Rule 16 initial order, the Rule 26F conference has been scheduled for August 27th. Ergo, in 21 days before this date is August 6th. Therefore, pursuant to the court's order, we must confer on or before August 6th. This Friday, at this August 6th or sooner meeting, you and I will discuss the standard scheduling order to see if we can agree upon certain discovery parameters. If we cannot, that's fine. The court will decide these issues for us at a rule. So basically saying the court is going to decide if you don't want to show up. With respect, I cannot see how talking with me over the phone would make you feel unsafe, considering that your residence in Michigan is nearly 900 miles from my location in Mississippi. Do you really believe that I will reach my hands through the telephone to inflict upon you some sort of physical calamity? If you truly believe that, then I am sincerely flattered that you think so highly of my capabilities. I like the cut of his jib. I like him. But I digress. The reality, Miss Yax, is that you are simply making excuses, and silly ones at that. Therefore, in good faith, I'm giving you one more chance to give me a day and time this week when we can discuss the boundaries of discovery. Is Wednesday, Thursday, or Friday good for you? I am free all 3 days. If you refuse to cooperate with my request, then I will simply prepare the scheduling order to the advantage of my client and submit the same to the court. Then, when we chat with the judge on August 27th, you can explain how your irrational fear, God damn it, cat, of me and telephones was valid cause to disregard the court's rules. What was the name of that judge? Or not the judge, the lawyer. Chris something. But he made some really, really spicy emails. Oh, what was his name? Rackets went over him. Chris something. Mr. Puppet might remember. I will also file an appropriate motion to learn the court how you believe its rules are irrelevant to you. We are not playing games with Yaks. Govern yourself accordingly. Oh, no, that's a threat. Oh, man, guys. Very clearly, govern yourself accordingly. That's a threat, ladies and gentlemen. That is clearly a threat. And then she doesn't put her response, which basically, if I remember correctly, was basically, I'm not giving you the fucking time of day. You might have wanted to attach that, by the way. Chasing Justice, 48 weeks ago. This is the best letter ever. Flattered. This broad lives in Michigan? Oy vey. She must know the court rules still apply to her. Well, yeah, with their ruling that she's within the jurisdiction, yes. Her last name is Yax. That is priceless. I forgot his last name, too. I know it's like, God damn it. What was his name? Chris something. Christopher Hook. He told opposing counsel to eat a bowl of dicks. Fuckface and fucktard. My boy. Gay boys, shit for brains, fuckface and fucktard. Sent to all states' lawyers. Are you in good hands? That was my boy. That was my boy, Christopher Hook. All right. Like my fucking uncle. My uncle was sanctioned so much because he just couldn't hold his tongue. She is so threatened by Matt and Chris, but just last week wished death upon one of her former mods. Okay, Karen. Yeah, I'm laughing about Yak from laughing. Yakety sacks. She's nuts. His response was white power symbol. Boom. We are not playing games with Yaks. Govern yourself accordingly. Blah, blah, blah. Okay, so it looks like she's just upset over this literal one chain. Because the email was entered into the file as an exhibit in a motion that the plaintiff's attorney put out to show that they were trying to confer with her, and she told them to fuck off. I know, and she's saying to Misty Evans, I know you were fed things, and honestly, I feel bad they played you that way. I felt bad when they were doing it. I would read the comments on your live and just want to scream, shut it down at you. I have no. Why doesn't Ray sue those people? I have no dice in this game, but that's one thing I will hang my hat on. She's a good woman with a huge heart. The people who you had behind you fed you BS. Where are those people now that you're being sued? And I am a good woman with a big heart. I mean, that's because of cholesterol and heart disease. It's not because you're a good person. If you know there's a group out to get Ray, why not offer that up? Offer it up how? She knows it herself. This was all going on long before I came along. 7 freaking years. Tell her who was behind it all. Tell her who you were conversing with. I've got nothing to offer her. Oh, so you didn't have anything and you were bullshitting. Except the apology I've been offering since June 5th. I don't want to say it, but I'm just going to say it. I think if there were people involved with you doing those lives and you were being paid like people have told us, I would offer up the who. Legal question. Is it illegal to attempt to hide assets to decrease net worth in order to reduce the amount of a monetary judgment? Apparently this is Ray. This is supposed to be Ray Andriacchio. My ex tried to hide assets and can blah, blah, blah. It can be. Trial of Michael Long. Remember Karen, October 18th, and you can't attend by Zoom. Don't keep Ray waiting. Sharing autopsy photos of someone's dead child around to your rapidly shrinking minion groupies is disgusting. Wouldn't it be, though? That'd be really, really disgusting. Like how you kind of tried to take me to task for... I'm drawing. When you try to take me to task for talking about things, and how you tried to get Ken Jennings fired for reading motions that you said were actually medical records, and they weren't, but you didn't actually read anything, so you're just stupid. Yeah, I'm still alive. Okay. I was like, man, I'm saying a lot of things that'd probably get this shut down. Like calling her retarded and stuff like that. It's bullying. Why does this picture, I'm dead serious, why does this look like a creepypasta Keffels? Why does this look like a fucking creepypasta Keffel's drawing? Yeah, she likes to share pictures, like when she and her groupies made fun of Sophie Long for claiming she was molested. Yeah, when she and her groupies are making fun of Sophie Long for having been assaulted. Weird that. Emily Harding, from her chat before, she either deleted it or made it super private. Imagine having your Telegram chat in a court document. Lamau, I'd be so embarrassed. Through the concerted efforts of Bilbo Mitchell, former DA, Cassie Coleman, current DA, blah, blah, blah. Forensic evidence and witness testimony has been suppressed and or ignored in an effort to ensure the case did not move forward, particularly individuals named above, engage in jury tampering to ensure the outcome they desired. Like, Ray, please, all these people made your sons murder a self-deletion? Whatever. Yeah. Court documents stand by WSAV, blah, blah, blah. I just received word from Ray that apologies and promises by themselves will not be enough. So unless you can make us a better offer, we will have to go to court for the settlement conference on a date the three of us choose. Basically, she wanted to say mea culpa, mea maxima fucking culpa, and walk off scot-free, not pay any money, not even have to say, I was wrong for this or anything. Just say, I'm sorry. Which, by the way, if you're offering an I'm sorry, it tells me that you're wrong. You can't defend yourself. Which would mean this is not a frivolous lawsuit anymore. So unless you can make us a better offer, blah, 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 please give us your dates. You claim financial lack. If that is truly the case, we'd like to see your bank statements and tax returns, which is a fair thing to request. If you could show that you lack the financial ability to go down to Mississippi for a pretrial conference, they'll probably work with you. And if they won't work with you, the court will. So you have two options there, and you chose not to make use of either one of them. So not like he's asking for the world. He's saying, look, just show us some evidence of this and we'll work with you. Or if you have information that too could be a substitute for money. Like, who told you all this crap, because we'd like to know. You were given an out. You were given an out, and you decided not to take it. Either way, just make us a better offer. With that said, my client may be amenable to accepting information in your possession as an offset to any financial demand we might otherwise have. Basically, look, you can give us money or you can give us information, but you're giving us something more than an I'm sorry. Or that time she and her friends passed around boot pictures of someone as revenge porn. I believe it. I fucking believe it. Really weird how she can take the moral high road when she's doing all this shit. Really weird that. For example, Ray just reminded me that you had said to Chris that you had information that would blow the investigation to Christian's death wide open. Ray also reminded me that you told Chris that you had been paid to represent Dylan and Whitley. Ooh. So if you have recorded conversations, voicemails, emails, text messages, Facebook messages, check stubs, receipts, evidence of payment, etc., basically any record of any communication with or of any kind or character with Dylan, Whitney, Jet Miller, Matt Miller, or any friend or relative of these parties, including but not limited to Frankie Wagner or Kelly Harper, or any other person who has knowledge or a personal interest into what happened to Christian Andriacchio, then my client may be willing to trade authenticated copies of these messages recordings for corresponding reductions in any financial settlement. Also, any offer by you would need to have a commitment to make a public and private apology, plus a commitment to never speak of this case or any of Christian's family ever again on any social media platform or other public forum. That's fair. Ken's counseling couch. Don't forget, Spectre, that this is the same woman who thinks any man in any context discussing a child's vagina is a pervert. Oh, yeah. She called me a pedophile, you a pedophile. I mean, I didn't even read over any of the documents. I just confronted, what's her name? Laura Elkind, Kelly Long's attorney, about her unethical and possibly illegal attempts to cajole, extort, harass, and intimidate people into not looking at stuff that was available to the public. But I was, I guess, a pedophile. She accused Nick Reichardt of being one. It's really weird how that works out, Ken. That's so fucking weird. Karen, this is a message I have been instructed to deliver from my client. I am quoting Ray word for word. Miss Yax, due to your dishonest approach in these settlement negotiations and your dishonest and disrespectful communications to the court through motions and filings, I am instructing my representative to withdraw all settlement offers and stop negotiations. I will leave it to a jury to determine the judgment your actions deserve, not what you can afford, but what you deserve. At that time, I will hire an attorney in Michigan and have the ruling of the federal court in Mississippi certified by a federal court in Michigan, and I will vigorously pursue collecting every dime of that judgment. At this point, the only thing that needs to be accomplished is setting a date and time for settlement, all settlement offers, and stop negotiations. I will leave it to a jury to determine the judgment your actions deserve, not what you can afford, but what you deserve. Oh, I'm sorry. Settlement conference per the magistrate's instructions. I will make myself available at a time agreed upon by you and Mr. Wilson. I do not have high hopes the conference will be fruitful, but I will make my validated concerns known to the court at that time. So that's what she's saying. She's saying all of this proves that Ray Andriacchio knows that this is a frivolous lawsuit and is vexatious. What were your responses, by the way? Okay. Might they be... Oh, God damn it. I'm going to have to go over here. Did they? I think they do. They don't. Okay, whatever. Thank God. I would love to see Kay's response, but I believe, if I remember, she basically told him to fuck off. Every time. Every time she tell him to fuck off. So I can understand why she'd be like, you know what? I'm done. I'm done playing with you. Go fuck yourself. Or bring it to a jury. Can't really blame her at that point. Victim plaintiff has insinuated on multiple occasions that she will drop her frivolous lawsuit against defendant in exchange for what plaintiff believes beyond any rationality that defendant is in possession of secret evidence which could serve plaintiff in the future in pursuing yet another never-ending criminal lawsuit against Whitley Goodman and Dylan Swearingen. To be clear, defendant has no knowledge of any secret insider information having to do with the 2014 death of Christian Andriacchio, and stated such to plaintiff innumerable times during defendant's attempts to seek a resolution of plaintiff, but she was saying publicly on her streams that she had information that would, quote, blow the lid off of it. So which one is it? I can understand now why they might be a little upset that you're jerking them around. Plaintiff's demonstrably vindictive and hostile conduct exhibited towards defendant both online and offline during the entire duration of plaintiff's claim, and including but certainly not limited to key conference dates outlined in the case management schedule, have served to further exacerbate tensions. Why is there a comma or a colon there? It's not like she was listing things. She literally says that. And have exhausted the goodwill of defendant, having irreparably undermined any possibility of engaging in a civil, productive, and time-efficient resolution between both disputing parties, both out of court and in a face-to-face alternative dispute resolution. Again, this is a narcissistic personality. She's acted like a bitch to the attorney for Ray Andriacchio in her responses. I'll find them. I'll put them out there so you can see how she's responded to it. In fact, probably do that here. I would love. I know she has. I know. You know what? I'm not going to. Not right now. I'll put it out there. Okay, but this is classic narcissism. Everybody else is being unresponsive, or everybody else is being hostile towards me. It's a paranoia thing, but it's more, I think, consistent with a narcissistic personality. Since Ken's counseling couch is in here, he could tell me if I'm on the mark or not. But I would argue that she's definitely showing that she is a narcissist. Everybody else is the problem. I'm over here being a good girl. I did nothing wrong. I have complied. Look at me. I'm even taking responsibility for not showing up last year as I make excuses as to why I didn't show up now. It's narcissism. It is a narcissistic personality that is writing this. Everybody else is wrong. Everybody else is abusing me, and I am the victim in all of this. And people just need to fuck off. Drop the lawsuit. It's vindictive because you're suing me. It's, your friends are harassing me. Your friends are doing the exact same thing to me that I did to Ken Jennings, Kiwi Farms Ken Jennings, to Nick Ricada, to Michael Long, to Sophie Long, right? Kay was attacking them. All under the guise of, I care about Sophie, even though she was making jokes about Sophie having been molesticated, shall we say. You'll excuse me if I don't believe you. Okay? Considering all the people plaintiff is recruited online to violently harass and terrorize defendant, incidentally, most of those individuals make up plaintiff's witness list. That's not even a fucking sentence. Plaintiff and her affiliates have, likewise, perpetually harassed and terrorized potential witnesses of defendants as such an alarming frequency, and for so long, defendant is limited to page constraints in identifying them all. Really? Where? Where's any evidence that they are harassing and terrorizing potential witnesses for you? Where? You're making an allegation, but you provide no supporting evidence. You are attempting some listen and believe bullshit, thinking I am a poor woman. I am a victim of this vexatious individual. I am being violently harassed, and the people around me are being harassed. And no, I don't have any evidence for it, but just take me at my word. It's happening. It's happening. Where's the evidence, Kay? Where the fuck is any of this evidence? Oh, well, they're too afraid to put affidavits or sign statements. And the court's going to ignore it. Sorry, it's just going to ignore it. Not sorry, because it's not happening. With that, defendant on account of her economic constraints, lack of access to reasonable legal counsel, and lastly, a legitimate fear for her physical safety, mental health, and well-being, whilst traveling alone to an unknown state to engage a plaintiff in light of her abusive, malicious, and relentless conduct. That's not even a fucking sentence. That's not even a full sentence. Now, I made a meme for this. I made a meme specifically about that last part. Critical K, in her mind, you're not ignoring me, Ray. I am a force to be reckoned with. I am a Powerball. You've never met a deleted expletive like me, Ray. And that's an actual quote from her, by the way. Reality. With that, defendant on account of her economic constraints, lack of access to reasonable legal counsel, and lastly, a legitimate fear for her physical safety, mental health, and well-being, whilst traveling alone to an unknown state to engage with plaintiff in light of her abusive, malicious, and relentless conduct. I'm a bully, right? In her mind, she's an alpha. She's ready to go. You haven't met someone like me, and then in reality, but I'm the victim. I'm the victim in all of this. Protect me. Fuck off. Fuck off with that shit. So, we get to the last motion. And this is Ray Andriacchio's response to Karen Yax's response. Ooh. It should be good. At the very least, we should get full paragraphs. So a lot better for me. Comes now the plaintiff, blah, blah, blah. Introduction on June 4th, 2021. Plaintiff filed suit against the defendant for defamation. Defendant filed her answer on June 24th. Excuse me. She also filed a motion to dismiss for lack of personal jurisdiction, which was denied. Docket 6 is I believe, the answer. 13 is docket 6 is the motion to dismiss for lack of personal jurisdiction, and 13 is the order denying that motion to dismiss. Give me one sec. I was just checking something. Apologies. Since then, defendant has been sanctioned for refusing to attend a telephonic case management conference. She also refused to attend a settlement conference as ordered by the court, for which plaintiff moved for sanctions and a default judgment. This memorandum is in reply to the defendant's response to said motion. Although plaintiff's underlying Rule 16F motion deals only with defendant's contumacious refusal to obey an order of this court, her meandering response touches upon various other topics. Plaintiff feels the need to respond to these assertions, which is fair. I can't believe she put 4 pages of nothing. Doesn't touch on the topic, but hey, here we fucking are. To this end, plaintiff will first describe how the complaint states a valid claim pursuant to Rule 8A, and they don't have to do this, by the way. They do not have to do this. She did not bring a 12B6 motion. She did not bring a 12B6 motion. She can't now claim that they have no case. That's trial material now. Right? I hate to break it to you. That's something that comes up at trial now. So we're clear. This analysis will identify the factual, non-conclusory allegations of the complaint that supports the elements of defamation per se and defamation by implication. Defamation per se is it's so defamatory that it's assumed damages have been inflicted. Okay, that's what that means. Next, the plaintiff will demonstrate how the complaint makes a valid prima facie case for asserting personal jurisdiction of the plaintiff. Prima facie means on its face, meaning it meets the bare minimum at the very least. Looking over something, sorry. Plaintiff will show that most of the factors delineated in Calder v. Jones, which I brought up earlier, and Revel v. Lidov. I know this case, but is that the one? I think that had to do with a cop. Can't remember. Don't quote me. I think it had to do with an FBI agent in 9/11. Point conclusively to a finding of personal jurisdiction. As for the other factors, plaintiff will also show the defendant has had the opportunity to present competent evidence showing that these factors favor her, but that she has failed to do so. Because the complaint states a valid claim and because the court has personal jurisdiction over the defendant, plaintiff will show that this court's order compelling defendant to come to Mississippi for a settlement conference was lawful and binding. A fortiori, because the defendant willfully refused to obey such a valid order, plaintiff will show that she should be sanctioned. Finally, the plaintiff will show that her actions throughout this proceeding have been proper. As such, the defendant's argument should be no excuse for her contumacious refusal. Just say her willful refusal to comply with this court's order. But again, it's a word that I had to look up, so, kudos. Plaintiff incorporates, by reference, the arguments she makes in her memorandum of law in opposition to the defendant's motion to dismiss, found at docket 10. The complaint states valid claims. Defendant begins her response discussing the holding in Twombly, which analyzes the specificity requirement of Rule 8A in the context of an antitrust claim under the Sherman Act. An allegation of parallel conduct, the Twombly court holds, is thus much like a naked assertion of conspiracy in a Section 1 complaint. It gets the complaint closest stating a claim, but without some further factual enhancement, it stops short of the line between possibility and plausibility of entitlement to relief. To this end, plaintiff will show that the complaint is sufficient factual enhancement. In Mississippi, the elements of defamation are as follows. 1, a false and defamatory statement concerning the plaintiff. 2, unprivileged publication to a third party. You meet both of those. 3, fault amounting to at least negligence on the part of the publisher. Certainly seems like that's the case if she's claiming she had sources that blow the lid off of it, and now she's saying she didn't. And 4, either actionability of the statement irresponsive of special harm or the existence of special harm caused by the publication. A statement is defamatory if it tends to injure one's reputation and thereby expose him to public hatred, contempt, or ridicule, degrade him in society, lessen him in public esteem, or lower him in the confidence of the community. To prove actionability, irresponsive of special harm, i.e., defamation per se, the statements must be 1. Words imputing the guilt or commission of some criminal offense involving moral turpitude and infamous punishment. 4. Words imputing a want of integrity or capacity, whether mental or pecuniary, in the conduct of a profession, trade, or business. And keeping in mind that she claimed that one of Ray Andriacchio's former patients had self-deleted. And I can't remember exactly how she worded it, but if I remember correctly, she basically blamed Ray Andriacchio, or at the very least was like, it's a weird coincidence that her son and this former client of this therapist both decided that it was a good idea to start a shotgun. I don't know how either one of them actually did it. I just want to make that very clear. First, the complaint recites statements that defendant made on YouTube. The complaint quotes defendant as she explains how plaintiff has, quote, attempted to control the narrative, end quote, about what happened to her son, Christian Andriacchio. And I am going to continue to lay the groundwork and continue to provide proof of the things that I claim that she has attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc. So, that would be accusing her of a crime, specifically blackmail, extortion, buying alcohol for underage people, bribery. Those are crimes, right? Those are crimes. That would be defamation per se. Plaintiff's averment that defendant made this statement is factual because a jury can use sensory perception to determine what the defendant said. Clearly, in the former category, I use statements of fact or assertions that describe present or past conditions capable of being known through sense impressions. Moreover, because the words are clearly designed to degrade plaintiff in the view of the public, this statement is patently defamatory. Likewise, plaintiff alleges that she has not committed bribery. This, too, is a factual averment since a jury using these impressions, using sense impressions, could hear plaintiff denying defendant's claim to bribery or alternatively hear a defense witness who supports such a claim. In this case, they're saying Kay could bring a witness who says, no, she attempted to bribe me. Thus, the complaint makes a factual, non-conclusory assertion that the aforesaid statement is false and defamatory. Therefore, the complaint makes a prima facie case in support of the first prong of the Phillips-Bros LP test. Second, the complaint alleges defendant operates an internet webcast with over 17,000 subscribers in which she discusses numerous real crime stories from across the states. The complaint also alleges that during a webcast, defendant made the statement referenced above. Thus, the complaint makes a factual, non-conclusory allegation that the defendant published this false and defamatory statement to thousands of people. Since the complaint alleges malice, the defendant's statement would not be privileged. Thus, the complaint makes a prima facie case in support of the second prong. Third, the complaint alleges that the defendant acted with malice and that she knew or should have known the statements were false. Pursuant to Rule 9b of the Federal Rules of Civil Procedure, malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. Therefore, the complaint need not describe a precise factual basis for these allegations in the same way that one must do for other elements. Thus, plaintiff has made a sufficient allegation regarding defendant's fault, therefore fulfilling the third prong of the test. Finally, the complaint demonstrates actionability response irrespective of special harm by showing how the defendant had accused plaintiff of a criminal offense involving moral turpitude and infamous punishment, bribery, extortion, buying liquor for minors. Moral turpitude includes, but is not limited to, actions which involve bribery. Conviction for bribing a witness to commit perjury shall be punishable by up to 5 years in prison. Thus, defendant's statement that plaintiff committed bribery is actionable per se. Therefore, the complaint alleges a false and defamatory statement, i.e., that plaintiff committed bribery, that was published to third parties without privilege, by which the defendant had fault, and that the statement was actionable without proof of special harm, since bribery is a crime of moral turpitude subject to infamous punishment. I don't know about infamous punishment, but whatever. The complaint states a claim for defamation by implication. In Journal Publishing Co. v. McCullough, The Supreme Court of Mississippi adopted the reasoning of the Ninth Circuit Court of Appeals in the Church of Scientology v. Flynn. There, an attorney for former Church of Scientology members made a speech in which he implied, but did not say, that the church tried to sabotage his plane. The Ninth Circuit held, although Flynn did not specifically accuse the Church of Scientology of attempting to cause his death, it would be reasonable to imply defamatory meaning from his remarks, basically implying that these people are the reason that X happened. You don't come out and say it, but you put enough in there to narrow down who you're talking about. That's the implication. In the case at bar, meaning the case in front of the court, the complaint alleges that the defendant said, I really do believe that Hayes was treated by Ray, and Hayes is now dead with a drug overdose, that he was treated by Ray. So, she has a son that is dead by self-harm, and she has a patient who is dead by self-harm. Again, she's trying to put these two together and saying that the only common factor is Ray Andriacchio, who was the mother of her son, Christian, and the therapist for Hayes. That's the only common link. Clearly, correlation is causation in this case. Plaintiff disputes the assertion that her son, Christian Andriacchio, died by self-harm. However, even if defendant's statements about Hayes Mitchell and Christian Andriacchio are correct, the implication of these statements in this context would be defamatory. That is because in context of these statements, the common denominator between the two men is the plaintiff herself. Ergo, a jury could find the defendant was implying that plaintiff was somehow to blame for the alleged self-harm of both men. The complaint also states, defendant gave the impression to her audience that plaintiff, who was a mental health service provider, may have been responsible for the death of her son and another man. Defendant's comments about Hayes Mitchell, when juxtaposed against her false assertion about Christian Andriacchio expiring from self-harm, leaves the false impression that plaintiff had somehow caused or contributed to their plural deaths. Thus, the complaint alleges the defendant made a false and defamatory implication to her YouTube audience, which would be a third party, because the plaintiff alleges malice, which may be averred generally as per Rule 9 Bravo. No privilege exists for the publication of this false and defamatory implication. Moreover, the defendant was at fault for the reasons described above. Therefore, the second and third prongs of the Phillips-Brose test are met. Finally, because the allegation impugned plaintiff's capacity as a mental health provider, she does not have to prove special harm. This would be defamation per se. Thus, plaintiff made a false and defamatory implication that plaintiff caused or contributed to the deaths of Hayes Mitchell and Christian Andriacchio that was published to third parties without privilege, her YouTube audience, with fault, and that the implication was actionable without proof of special harm since the statement impugns plaintiff's professional capacity. Therefore, the complaint states a valid claim for defamation by implication. The court has jurisdiction over defendant, therefore the court's order is binding upon her. This is pretty much self-explanatory. Having established the plaintiff has stated valid claims, plaintiff will now address the question of personal jurisdiction, which is a really simple one. She filed a motion to dismiss. The court said, no, you meet the requirements to have minimum contacts with the informed state. We have jurisdiction. Your motion is denied. When a non-resident defendant presents a motion to dismiss for lack of personal jurisdiction, it is the plaintiff's burden to establish that in personam jurisdiction applies, meaning personal jurisdiction. They really wanted to hammer in that Latin, and I applaud them. I like Latin classes. Lubin v. Delta Airlines, citing Wilson v. blah, blah, blah. The court may determine the jurisdictional issue by receiving affidavits, interrogatories, depositions, oral testimony, or any combination of the recognized methods of discovery. If the motion is decided without an evidentiary hearing, the plaintiff only needs to make a prima facie case that jurisdiction exists and is not required to establish jurisdiction by a preponderance of the evidence. In such case, the court must resolve all undisputed facts submitted by the plaintiff, as well as all facts contested in the affidavits in favor of jurisdiction. That doesn't mean that if the plaintiff says, we have jurisdiction because I say so, that a motion to dismiss is immediately void. The court's always going to come down on it. The plaintiff still has to make the argument. And in this case, Karen Yax had talked to people in Mississippi intentionally and had directed comments to Ray Andriacchio in Mississippi, and I believe even tried to contact Ray directly, calling her up, which would, under Calder v. Jones, be enough to establish personal jurisdiction. Let me see. By previous order dated November 19, 2021, the court denied the defense motion to dismiss for lack of personal jurisdiction. Therein, the court states the defendant reserves her right to renew her motion with appropriate evidence at a later juncture. Thus, the defendant could have presented competent evidence in support of a renewed motion to dismiss for lack of personal jurisdiction. In fact, she could have asked for an evidentiary hearing. However, she has done neither. On March 22nd, 2022, the defendant filed another motion to dismiss, but she attached no exhibits. Then on July 5th, having not heard back on the March 22nd one, the defendant filed a third motion to dismiss along with other requests for relief, including summary judgment, which is a really bad idea because if you're asking the court to make a finding, a summary judgment, it's a good chance you're putting yourself willingly in the court's jurisdiction. Might want to be careful on that. Again, we're almost 2 hours in. I have to reiterate, not a lawyer. I'm a layman. I'm an artard reading this and trying to give you an idea just from a normal person's perspective. This is not legal advice or anything like that. It should not be construed as that. So calm down. This motion had two exhibits. However, neither exhibit bears upon the question of whether the court has personal jurisdiction over the defendant. Also, neither exhibit contains sworn statements. Thus, defendant still has not provided any competent evidence that should change the court's mind concerning personal jurisdiction. Thus, the current finding of the court vis-a-vis personal jurisdiction still stands as it should. Here is why. Minimum context: the complaint alleges that defendant interviewed Mississippi residents over the telephone about the death of plaintiff's son. I don't know if it was over phone. I believe she used something like Zoom to do it, but for the purposes of something like this, that would count as telephonic. That too, she conducted in-depth discussions about the official investigative file that was prepared by Mississippi law enforcement personnel, in that she directed at least one message to the plaintiff, personally stating the second one, if she's just reading over the paperwork, the legal the official investigative file, I don't think that would meet minimum requirements. I mean, I'm reading over this, right? I'm reading over this. If I'm not directly saying anything to either one of them, would this put me within the realm of Michigan or Mississippi jurisdiction? I don't think so. So I'm not sure about that one. But she directed at least one message to the plaintiff, personally stating, and I put this in the meme, "You're not ignoring me, Ray. I am a force to be reckoned with. I am a Powerball. You never met I'm assuming it's bitch. You never met a bitch like me, Ray." Therefore, unlike the defamatory article referenced in Revel v. Lidov, the defendant's comments on the case sub judice reference the forum state itself and the activities of the plaintiff in the forum states. Basically, what they're saying is, by addressing Ray directly, she is aiming her message to Mississippi and at least one resident, Ray, who lives in Mississippi. Moreover, unlike I read that. Also, the defendant made at least one of these defamatory comments while Mississippi residents were on the phone with her. Thus, defendant could have foreseen that the injurious effect of her intentional tort would have been felt in Mississippi. Unfortunately, if one person from the foreign state hears it, this is a good case that jurisdiction applies if you have knowingly interacted with that person from the forum state. As we saw in, who was it? Toddy Westbrook v. Without a Crystal Ball. Toddy Westbrook claimed that with, what's her name? Katie Joy, I think it is, which is a dumb name. That's not her real name, but whatever. But she argued that because at least one person on her Patreon or following her on Facebook or YouTube was from Washington, I think it was Washington. We're going to go with Washington. Then it meets the minimum requirements. But unless Katie Joy knew that person was from Washington, it really doesn't. In short, most of the factors that bear upon the minimum context analysis favor the plaintiff's position. Any factor that does not favor or disfavor plaintiff's position deals with the number of people in Mississippi as compared to those from other states who comprise defendant's audience. Presumably, defendant would have this information in her possession. However, she has presented no sworn statements or other competent evidence to suggest how much of her audience is comprised of Mississippians. Instead, all she has presented is unsubstantiated allegations and hearsay. Therefore, because defendant has failed to produce competent evidence to support her contentions, plaintiff suggests that any remaining factor pertaining to minimum contest or contacts must be unfavorable to defendant. Ergo, defendant had sufficient minimum contacts with the state. Filing suit in Mississippi is not unfair to defendant. The Fifth Circuit lists the factors that a court must consider when determining if it is fair to assert personal jurisdiction over a non-resident defendant. They are: 1, the burden on the non-resident defendant; 2, the forum state's interests; 3, the plaintiff's interest in securing relief; 4, the interest of the interstate judicial system in the efficient administration of justice; and 5, the shared interest of the several states in furthering fundamental social policies. So, let's say that you didn't have the minimum contacts, right? Let's say going from Michigan to Mississippi is probably not cheap, especially when you consider flight, hotel lodging, car rental, food, probably not cheap. Excuse me, right? And flying back, obviously. There's a burden on the defendant there. The forum state's interest. Does Mississippi have an interest in it? Well, if you can't establish the minimum contacts, no. Plaintiff's interest in securing relief. Plaintiff's always interested in securing relief, right? But those first two are probably the most important. If you can't establish one of those, or in the case of number one, if the burden would be incredibly noticeable, for example, Alaska to Florida, the court is more likely to say no, or at the very least, allow for at least pretrial stuff to be attended telephonically. You don't have to come in person, right? Something like that. That might be something to consider. And if you can't establish minimum contacts, state really doesn't give a shit at that point. When the court ruled that plaintiff had made a prima facie case in support of personal jurisdiction, the court stated the defendant could renew her motion later with evidence to support her position. Thus, defendant could have presented evidence particularizing the burden she would incur by defending this suit in Mississippi. However, she has not. And this goes back to, again, she could attach bank records, which they asked for. Look, give us something to validate this. And she didn't. She decided to be a bitch. She decided to continue to play stupid games. She's fucking around, and now she's finding out. For example, defendant has lamented about her financial state throughout the entire proceeding, yet she has provided absolutely no affidavits or documents such as tax returns, bank statements, her Patreon statements where she gets donations from her viewers, pay stubs, etc. to support this claim. I actually kind of want to see what's Critical K Patreon. How many people are following her? I have to use Social Blade. Patreon subscriber number. Craftrion. All right, so. Oh, she has like 500 people following her, so that's like $500 a month minimum, probably a lot more. Oh, she has 550 right now. Earnings is apparently like 206. That doesn't sound right. Patreon monthly. Yeah, okay, so whatever. Point is that she's not putting anything in there, right? There's no evidence. Pay stubs, etc. to support her claim. Instead, she has made unsubstantiated claims about her poverty. Beyond this, it is clear from the exhibits to her response that either she or her husband works for Ford Motor Company and is a member of the United Auto Workers, which is a union. The court may take judicial notice of the pay scales and benefits that UAW workers receive from Ford Motor Company by accessing their most recently published collective bargaining agreement located at, and there's the link for it. You can look at it if you want. I don't really give a shit. In short, the court has personal jurisdiction of the defendant. She has directed her comments to Mississippi. She even defamed plaintiff while talking to a Mississippi resident whom she was interviewing. Moreover, defendant has failed to provide any evidence that would demonstrate anything to the contrary. 4, the plaintiff has no valid reason for disobeying the court's order, therefore sanctions, including default judgment, are warranted. Again, I don't think they're going to get default judgment. Don't think it's going to happen. It's going to be sanctions. I don't think they're going to get the default judgment. I don't know if I'll be pleasantly surprised if I'm wrong on this. I'll be surprised, but I don't know if it'll be pleasant. Because the complaint is not frivolous and because the court has personal jurisdiction over the defendant, the court's text-only order compelling her to come to Mississippi for the settlement conference was enforceable. Therefore, we may now address the substance of the sanctions motion. To prove that the defendant is in civil contempt, plaintiff has the burden of proving 1, that a court order is in effect. It was. 2, that the order prescribes or requires certain conduct by the defendant. It does. And 3, that defendant has performed an act or failed to perform an act in violation of the court's order. And she did. Court ordered the defendant to come in person to the settlement conference on pains of being sanctioned. This order was still in effect on October 18th. Notwithstanding, defendant did not appear at this hearing, as noted by this court's own docket entry from that date. Therefore, plaintiff has met her burden of proof. Yeah, that's pretty self-explanatory. It's pretty straightforward. Now, the defendant must assert defenses or mitigating circumstances that might cause the court to withhold the exercise of its contempt power. Where a legally sufficient defense is asserted, such as defendant's present inability to comply with the order, this burden is merely one of production rather than persuasion. So basically, she had to show evidence. It's basically, show me, don't tell me. However, where defendant offers a mitigating circumstance such as good faith, the court may tailor sanctions in light of the circumstances offered. So basically, if she came back and was like, look, here's a doctor's note from a certified physician saying that I had COVID, or I had some communicable disease, or I was in the hospital during this time frame, then the court could go, that's fair. You were in the hospital. You were actually hospitalized in the ICU, or, your child was in the PICU or something like that. Okay. The point is that she had provided anything like that. The court would be like, you know what? That's fair. We're not going to sanction you. You have a valid reason. She doesn't show anything like that. She just alleges. She doesn't even allege anything. She just says, I didn't show up because I was scared. That's literally it. In a response, the defendant offers purported defenses or mitigating circumstances. However, plaintiff submits that none of these should be persuasive. Defendant states that she had the inability to come due to financial reasons. In her own words, she does not have the disposable income to arrange continual round-trip airfare to travel to a foreign jurisdiction to engage in a 20-minute mediation conference with an undoubtedly hostile and vexatious litigant, which will inevitably result in a fruitless outcome. However, as stated above, defendant has offered nothing to support her contention of poverty, even though she had mailed her original motion to dismiss from Hawaii. That would point to it's not really poverty she has. Beyond this, defendant contends that a settlement conference would have been futile since, as she puts it, plaintiff is, quote, undoubtedly, I'm very upset with you, Matt. That says undoubtedly, and you put undoubtedly. Very upset with you now. Hostile and vexatious litigant. However, what defendant fails to realize is that the requirements of Rule 16F are binding not only upon her, but also the plaintiff. In other words, if defendant had traveled 1,000 miles to Mississippi, incurring great expenses and trouble in the process, only for plaintiff to behave vexatiously, then the court could have sanctioned the plaintiff for acting in bad faith, even to the point of dismissing her entire complaint with prejudice. Basically, if she had shown up and gotten Ray to basically admit that she was doing it vexatiously, or Ray acts like a total cunt, she could have moved for this sanctions herself to include dismissal with prejudice. Given the distance that defendant would have had to travel, the court naturally would have held the plaintiff to an exceptionally high standard of cooperation and reasonableness. If, for example, the plaintiff had taken her proverbial marbles and gone home without making a reasonable attempt to compromise, plaintiff would have been severely sanctioned for wasting defendant's time, to include travel expenses and the like. Thus, plaintiff would have felt more pressure to settle than the defendant. Put simply, the settlement conference was the best way for defendant to walk away from this matter without having a judgment being entered against her. However, by refusing to comply with the court's order, defendant missed this golden opportunity to settle this matter. Sadly, she knows it too. Defendant understands the benefits of attending in-person mediation. It is an important tool utilized by the court to conserve resources, to find common ground between two parties, and possibly come to a mutual agreed settlement in order to avoid a costly, lengthy trial, in order to save everyone time, money, and unnecessary burden to the civil court system. Nevertheless, she refused to obey the court's lawful order, and she has presented no valid excuse for not obeying. The plaintiff has acted properly and in good faith. Defendant makes various other claims, including the following. Plaintiff has insinuated on multiple occasions that she will drop her frivolous lawsuit against defendant in exchange for what plaintiff believes beyond any rationality that defendant is in possession of, quote, secret evidence, end quote, which would serve plaintiff in the future in pursuing yet another never-ending criminal lawsuit against Whitley Goodman and Dylan Swearingen. Presumably, defendant thinks this is a valid excuse for disobeying the court's lawful order. It is not. At the outset, plaintiff objects to defendant's attempt to introduce evidence of Rule 408 settlement negotiations. Without waiving this objection, plaintiff will state the following. And as a general rule, entering settlement negotiations, what was talked about in settlement negotiations, you can't do it. They're kind of like an off-the-record thing. Court really doesn't care except for the final outcome. Did you come to an agreement or not? If you did, good on you. We'll get an order, send me proposed orders. We'll get it written up. If you didn't, let's set time for trial. Let's set the dates for trial. That's all they care about. As a general rule, the stuff you talk about in the settlement negotiations is not eligible to be entered into the record or evidence. Defendant declared on YouTube that plaintiff had committed bribery to advance her narrative about what happened to her son, Christian Andriacchio. Defendant also implied that plaintiff had caused or contributed to the deaths of Christian and another man, Hayes Mitchell. Truth is a complete defense to an action for libel. Furthermore, the plaintiff has the burden of proving falsity. Internal citation quotation omitted. Since defendant asserted truth as an affirmative defense, if this matter goes to trial, plaintiff would have to prove that she did not commit bribery or contribute to the deaths of either man, which I really don't like that, because how do you prove you didn't? Right? I would think it would be on the defendant at that point. It seems like an affirmative defense. Affirmative defense, I think generally the defendant has to prove that X happened. You can't really say that something didn't happen. Plaintiff also contends that defendant acted with reckless disregard for the truth, and she made these false and defamatory statements and implications. Because reckless disregard for the truth employs a subjective standard, plaintiff needs to review all communications that defendant has conducted with anyone associated with the Christian Andriacchio investigation to ascertain whether defendant had a good faith basis for her false and defamatory statements. So if the defendant could offer evidence and say, look, this looked good, I relied on this evidence. If it's wrong, I apologize profusely. If she had come out and said that, if she could provide anything, she'd be good to go. She'd be good to go. Well, not really good to go, but it would definitely mitigate things. And it's definitely a defense that would probably cause the plaintiff to try to force some type of settlement in order to not lose, right? Plaintiff also contends that defendant... Oh, I just read that. Plaintiff needs to review it. On May 19th, plaintiff propounded request for production of documents upon defendant. Included therein was the following request. Request number 4. Produce for inspection and copying any and all documents, emails, text messages, social media messages, photographs, video recordings, audio recordings, facsimiles, and other messages that relate in any way to the death of Christian Andriacchio that you have received from any person. Despite having received this request, defendant did not respond with any such information when she provided her responses on or about June 24th. And she didn't assert journalistic privilege, right? She could have asserted that. I don't know how well it would have gone, but it would have been something. She didn't provide anything, meaning she doesn't have anything. And it'll be interesting if and when this goes to trial, how she gets around that if she actually does have something. Plaintiff notes that the suggestion raised by her attorney to defendant in this August 30, 2022 emails were made after plaintiff had propounded a request for production. Thus, defendant was already obligated under Rule 34 of the FRCP to provide this information if it existed, to support directly upon critical elements of plaintiff's claims, meaning she was required to provide it anyways. All she was saying was, look, you provide it, we can validate it. It helps you. It doesn't hurt. It doesn't help us. It actually helps you. I mean, it helps her as well because now she can look at who's saying stuff, maybe go after them, but it also helps Kay. Plaintiff could have filed a motion to compel. However, in view of the defendant's history of obstinately refusing to obey the court's orders, defendant likely would have disregarded the court's order if such motion were granted. After all, she once refused to come to a telephonic case management conference because she was, quote, scared, end quote. More recently, she refused to attend the court-ordered settlement conference after being specifically ordered. So, in good faith, plaintiff suggested that defendant could provide essentially the same information as part of a broader settlement package. Although this information would no longer be needed for trial if a settlement was reached, plaintiff believed that such information, if it did exist, had value and that it might bring her closer to finding out what happened to her son. Regardless, plaintiff had the right to sue defendant for her malicious, false, and defamatory comments. Defendant publicly taunted a grieving mother whose son had died a most violent death. Then, defendant lied about plaintiff's actions. Given the grief that plaintiff had suffered, defendant's lies would shock anyone who possessed a conscience. Her actions crossed the line, so the mere fact the plaintiff would consider settling for a reduced sum plus access to information that defendant was already obligated to give her testifies to plaintiff's character and good faith, which we saw in the emails. Plaintiff was willing to settle. She was willing to exchange a dismissal with prejudice in exchange for money, probably pay my legal bills. Good chance that it would have been pay my legal bills, right? Good chance. If she got the information she wanted to go after people and it could be vetted, she'd be like, pay my legal bills, there you go, you're out of here. They fucked around and is now finding out. Defendant, however, has only been playing games. Now plaintiff respectfully submits that defendant should be sanctioned accordingly. Entry of default judgment is an appropriate sanction when the disobedient party has failed to comply with a court order because of willfulness, bad faith, or other fault on its part, as opposed to its inability to comply with the court's order. And yeah, you can make the argument that her basically taunting the court in those telegram messages would constitute that. Because her disobedience was willful and because she has demonstrated absolutely no inability to comply, a default judgment should be entered. Again, I don't think it's going to be, I think it's going to be a hefty monetary fine, a reprimand, and it'll probably be a bigger moment, right? Don't fuck up again, because then they might actually give a default judgment, since it'll be strike 3 or out. And then it's just the conclusion, which basically lies out everything. Wherefore, premises consider plaintiff Andriacchio prays that this honorable court grant her motion for sanctions as well as her motion for default judgment. So, no, hey, it's certificate of service, yeah. Okay. I mean, it was signed. Was hers? No, she didn't sign it. I'm just saying. Okay, so there you go. Those are the Critical K lawsuit updates. She's in deep shit. She has put together 4 pages of saying absolutely nothing. It is run-on sentences, half sentences. It is absolute garbage. Obviously, the plaintiff has a lawyer, so it looks a lot more professional. Karen in the past has ignored the courts. She ignored the court here. Taunted the court. I would be a little, if I were the judge, I'd be a little more pissed as well. If I were taking everything in a vacuum, I'm not sure if I would grant default judgment, but I would make it very clear that you have like one more chance. And if you piss me off, if you ignore me one more fucking time, I will give a default judgment against you, because you've shown me you don't care about what I say. Now, I do have to say this. Allegedly, Karen has a plan. Karen expects to lose. Karen's plan is to file for bankruptcy after she loses. She thinks that this will discharge the debt. Unfortunately for her, one, they plan to have a federal court in Michigan uh, sanction the debt, which would make it a lot harder for her to get out of it, right? Because the biggest problem is just because you get a judgment in your favor, collecting from somebody out of state, in fact, out of the circuit, makes it more difficult. It's very difficult to do so. You got the judgment, you got the win. Sure, you can fuck with their credit rating, but you may not get the money. She thinks that this will help her. A bankruptcy would discharge the debt. Probably what Amber Heard thought as well. But that's what Karen thinks. Unfortunately for her, the Fifth Circuit Court of Appeals has made it very clear that this cannot be discharged through bankruptcy because it was a willful tort. It was a willful and malicious tort, which means that she knew she was doing it. You can't get rid of something like that. And if a federal court in Michigan sanctions the debt, the judgment, that federal court will also be authorizing the Fifth Circuit decision in that regard. Do I know for a fact that Karen is definitely going to? No. But that's what I've heard from, I guess, somebody who spoke with her. And again, I don't know who this person is. It could be bullshit. But this person also said that as early as a week before, Kay may not have been showing up. Kay was talking about not showing up. I don't know. I don't know who they are. So take that as you will. So there you go. There's the filings. There is the absolute shit show that is Karen Marie Yaks, Critical K. Now you can understand why she's being sued. The narcissistic personality. I mean, she's just a piece of shit. She's a piece of shit. She's a... What else do you say? I mean, she laughed about a girl being sexually assaulted. She doesn't read anything, even though she claims to be a true crime channel. She's a gossip channel. She's a 49-year-old, overweight woman with God knows how many cats. She gossips. She's a tea channel. She harasses people, as evidenced by her harassment of Kiwi Farms' Ken Jennings. She attempts to be a bully, and when people fight back, she blames them. Again, in her own response, she states that people affiliated with the plaintiff or sent out by the plaintiff to harass her are unacceptable. But that's what she did against Michael Long, Nick Ricada, myself, Kiwi Farms' Ken Jennings. She and her little cabal of cat ladies, of Karens, a screeching of Karens, did that to us. And she was one of them. So take that as you will, guys. So that's the end of the stream. I have to go back to cleaning. I have like an hour or two to do some cleaning because I have an appraiser coming in for the house. So you guys have a good one. That is it for this stream. Have a good one. The other channel on Sunday, I will be streaming with the guys. We're setting up the 2v2 Darkness Falls, 7 Days to Die PvP match. I may do another stream tomorrow, depending. I don't know. It'll probably be a gaming stream. So you guys have a good day. Have a good night. Enjoy it. And maybe you'll tune in on Sunday. Don't know. Link to that channel is down in the description. I'm Spectre. Thanks for watching.